Good morning everyone. Basa na tayo ng ating libro guys. Sariling history book. Kapwa ko Filipino, magbasa tayo ng ating history. History of the Filipino people by Agoncillo and Guerrero. Today is 21 March 2023. History of the Filipino people, Part 6, The Third Republic. Topic number 27, Profile of the Economy. Nandito tayo sa paragraph, The Courts on the Retail Trade and Parity. Basa. The courts on the retail trade and parity, the desire of the Filipino economic nationalists to expand their opportunities and participation in the economic affairs of their country was quite naturally vigorously opposed by the entrenched alien businessmen, particularly by the Americans who dominate the economy of the country and consequently did not want to lose their stranglehold on it. The Retail Trade Nationalization Act, Republic Act No. 1180, was passed in 1954 and was to take effect 10 years later on June 18, 1964. In order to give the foreign business establishment enough time to make certain adjustments, the law provides that only Filipino corporations, associations, and partnerships wholly owned by Filipinos can engage in retail trade. This was challenged by the Americans who anchored their arguments on the so-called Parity rights, and especially in the Laurel-Langley Agreement of 1956. The exploitation 1956, which extends American rights in the Philippines not only to the exploitation of the natural resources of the Philippines and its transportation business, but also to all economic activities. The Filipino nationalists challenged the validity and morality of the American contention that the Laurel-Langley Agreement and Parity give the American corporations, partnerships, and associations more rights than the Filipinos in the latter's country, and that those American business establishments, even if not wholly owned and controlled by American citizens, can engage in retail trade. The Macapagal administration, speaking to its Solicitor General, who distinguished himself by being frequently defeated in the courts of law, maintained that the Philippines had committed herself to the policy of exempting American business firms from the operation of the Retail Trade Nationalization Law. In view of the opposing views on the matter, the Philippine Packing Corporation and other American firms went to court to get a judgment. On December 16, 1966, Judge Hilarion Harencio of the Court of First Instance of Manila ruled that the Americans and their business enterprises are prohibited by the Retail Trade Nationalization Law from engaging in retail business. He cited that law's definition of retail trade, which includes sales in limited quantities to the general public of consumer goods for personal or household consumption, but also sales for industrial or commercial consumption, said Judge Harencio. It does not mean that the Philippines had renounced its inherent right as a sovereign state to enact laws and adopt ordinances and regulations for the sole protection of Filipino citizens, and when it does so, such a law will automatically operate in favor of American citizens. Otherwise, it will be open to the charge of discrimination. Haba pala nito. The judge, pasensya na sa mga noise. Late na naman ako nagbasa kasi. The judge also cited ordinances and laws in different states of the United States restricting certain professions and business activities to Americans. It is obvious, he added, that it is often necessary for an independent nation to adopt laws and regulations to protect its citizens and limit the right to engage in certain activities to them. Judge Harencio's decision jolted the American businessmen in the Philippines and even those in the United States. Therefore, was compounded when the following day, December 17, the Supreme Court, speaking to Justice Jesus G. Guerrero, whose decision on the Parity Clause was incurred in by all. The justices, including Chief Justice Roberto Concepcion, defined the limits of parity that was imposed on the Philippines immediately after World War II in exchange of rehabilitation dollars. The case arose when the San Jose Petroleum Incorporated, a Panamanian company doing business in the Philippines, claimed to be American-owned in order to enjoy the fruits of parity rights. The Supreme Court ruled that the business enterprise to be entitled to parity rights in the Philippines in the Philippines must be owned and controlled by American citizens, so the states give reciprocal rights to Filipinos. Justice Barrera anchored his decision on the fact that the so-called American Petroleum Company was not 100% owned and controlled by American citizens but by the two foreign corporations. Justice Barrera himself admitted that the significance of the court may tilaok pa naman na may naging bahala na kasi mga sons. Okay, the Supreme Court ruled that a business enterprise, ulitin ko lang ha, the case arose when the San Jose Petroleum Incorporated, a Panamanian company doing business in the Philippines, claimed, kasi nga guys, dikit-dikit yung bahay namin dito sa aming tinirahan, kaya maririnig niyo yung sounds ng kapitbahay, lahat na. Pati tilaok ng manok, lahat na. O yan, panay ang tilaok. The Supreme Court ruled that, ulitin ko, the case arose when the San Jose Petroleum Incorporated, a Panamanian company doing business in the Philippines, claimed to be American-owned in order to enjoy the fruits of parity rights. The Supreme Court ruled that a business enterprise to be entitled to parity rights in the Philippines must be owned and controlled by American citizens, so states give reciprocal rights to Filipinos. Justice Barrera anchored his decisions on the fact that the so-called American Petroleum Company was not 100% owned and controlled by American citizens but by two foreign corporations. Justice Barrera himself admitted that the significance of the Supreme Court's decision lies in the fact that in the enjoyment of parity rights, Americans cannot have more rights than Filipinos. The economic effects of this court ruling on the Philippine economy will be determined by later events, especially by the reaction of the American government, which will naturally protect the business interest of its citizens and will do everything in the power to make such protection effective. The immediate effect of the Herencia ruling was that the American business enterprises led by the ESSO, fearing that the Supreme Court might sustain Judge Herencia's decision, tried to effect a compromise by appealing to President Marcos. Oh, nandito na sa President Marcos, yung senior to. Tried to effect a compromise by appealing to President Marcos for the latter to intervene in the matter. When Marcos did not intervene, the Philippine Packing Corporation appealed the decision to the Supreme Court, which has not yet 1969 rendered a decision. At any rate, the two decisions were favorably greeted almost unanimously by the people, but particularly by the nationalists, who have been the consistent and vocal critics of what they have always regarded as the American attempts to colonize the Philippines for a second time. This second colonization being greatly advantageous to them than to the Filipinos, because the Americans have been enjoying economic rights and privileges in the Philippines without the corresponding responsibility. A few voices, mostly coming from Filipino serfs, who have not yet forgotten the sound of the chains of colonialism, are so pessimistic as to predict an economic dislocation of the Herencia decision became effective and implemented. However, Manila's Mayor Antonio J. Villegas immediately tried to implement the retail trade nationalization law and filed a case with the Supreme Court to test the validity of the Marcos administration's contention that the Herencia decision was not yet final, and so the opinion of the Department of Justice should prevail over the decision of the Judge of Court of First Instance. In the memorandum of the Undersecretary of Justice, Judge Herencia's decision was upheld. The Supreme Court ruled that all local executives, including the Mayor of Manila, were bound by the President's order. Villegas appealed for a reconsideration, but the Supreme Court dismissed his petition. Consequently, Mayor Villegas was compelled to give licenses to business firms wholly owned and controlled by Americans to do business in Manila. End of Parity. End of parity. For 20 years since its approval in 1954, the Laurel-Langley Agreement had been the basis of the special trade relations between the Philippines and the United States. According to Section 11, Article 17 of the Constitution of 1973, the rights and privileges granted to Americans under the parity provisions of the 1935 Constitutions as amended shall automatically terminate on July 3, 1974. Thus, at midnight of July 3 to 4, 1974, the agreement expired, and so the trade privileges enjoyed by American citizens in the Philippines also expired. On the other hand, Philippine exports to the United States, except sugar, which is covered by the Sugar Act of the United States, became subject to the full 100% tariff and other duties. In place of the Laurel-Langley Agreement, a Treaty of Commerce and Amity has to be concluded to regulate the future trade relations between the two countries. To date, June 1976, no such treaty has as yet been concluded. With the expiration of the agreement, American business firms in the Philippines were required to yield at least 60% of their holdings to Filipino citizens. And so far, however, as Americans' land holdings were concerned, President Ferdinand A. Marcos issued yung tatay to ni President BBM ha. President Ferdinand E. Marcos, yung E kasi is Idrolin yan. E. Marcos issued a presidential decree providing that the termination of the American land holdings in the Philippines would take effect not simultaneously with the termination of the Laurel-Langley Agreement but on May 17, 1975. Under the decree, American citizens or corporations owning lands in the Philippines acquired from private individuals are covered by the extension granted by the decree, but land holdings acquired from the Philippine government must be disposed of at once. Bukas na itong guys. Itong next paragraph, the growth of labor unions. Bye everyone. God bless.